Hello everyone, this is Dr.P.Syamala from the Department of MBA International Business, Acharya Nagarjuna University. And coming to today's topic, this is related to types of companies. In previous session, we have learned about what is a company, what are the features of company, definition of company, etc. Okay, and now what are the different types of companies? Okay, so types of companies can be differentiated according to or else on the basis of incorporation, on the basis of liability, on the basis of control, okay, or else on the basis of place of registration, basis of legality, okay. Many aspects are there depending upon the basis, okay. This types of companies are differentiated, okay. Basically, majorly, if we see means incorporation. Types of companies will be depending on the basis of incorporation, on the basis of liability, on the basis of control, okay. So if we see means first aspect on the basis of incorporation, okay. So on the basis of incorporation means here on the basis of incorporation can be studied under three headings. One is chartered company, statutory company, and registered company, okay. So first thing is under incorporation means company is incorporated on the basis of royal or chartered company, statutory company, registered company. Royal or chartered company means actually this is formed in England and now it is not existed, okay. In India it doesn't existed, but these companies are incorporated under specified charter like East India Company, Bank of England, and Companies Act is not applicable to these type of companies. Like I said before, East India Company, Bank of England, likewise, okay. Why? Because they are incorporated, okay, or else they are created and regulated by the king or queen. So but now these are not existed in India, okay. For if we want to say as an example means we can say East India Company incorporated in 1600 AD, okay. So therefore these type of companies are known as, okay, royal companies or else chartered companies which were not in existence now, okay. And if we see statutory company, what does statutory company means? Okay, these companies are formed under special act of parliament or state legislature, okay. So companies are formed, okay. These companies, statutory companies, are formed on the basis of a special act which is created in a parliament or else in state legislature, then company will be formed. If we see, basically this type of statutory companies are formed to undertake business of national importance, okay. So this type of national importance, which have national importance, so this statutory, for example, if we see what type of businesses can be seen, what type of companies can be stated under statutory companies means like Reserve Bank of India, RBI, SBI, LIC, UTI, okay. So which are owned and controlled by the government, we can say that, okay. And statutory means they are owned and governed are controlled by the government, okay. And for this type of statutory companies, okay, MOA and AOA, Memorandum of Association and Articles of Association, is not required, okay. Why? Because they are owned and controlled by the government itself. Therefore Memorandum of Association or Articles of Association is not needed. So we all know Memorandum of Association or Articles of Association states about the relationships, aims and objectives, okay. And relationships with outsiders, okay, the internal management and outside management of a company. But all these are regulated and are controlled by the government itself. So therefore there is no need for MOA and AOA, okay. And at the same time these statutory companies, okay, like RBI, SBI, LIC, UTI, they need not use the word limited, okay, limited with their name. Actually, if we studied the rules and regulations regarding a company, means definitely a company, if we read in features, okay, we have studied in features of a company. There we have studied about every company, at the last, the name of the company last word should be either limited, either public limited or private limited. There should be a name given, okay, as a suffix at their name, okay. Therefore, at the same time, it is a separate legal entity. These type of statutory companies are separate legal entities which are audited by the Comptroller and Auditor General of India for statutory company. Okay, so this is about statutory company which is controlled, owned by the government. And coming to registered companies. So what are registered companies? Registered companies are incorporated under the Indian Companies Act 2013 or an earlier act fall under this category. Means we all know that 2013 Act, Companies Act, previously we have 1956 Act, previously we have another act from 1800s. So Companies Act is being amended and new name is given. So here registered company means any act now which is applicable from now, that is 2013 to previous any act regarding companies law, okay, so fall under this category, okay. So registered companies, so these type of companies which are incorporated according to the Companies Act means these are called as registered companies, okay. So the rights and liabilities of members are governed by the provisions of the Companies Act or the special act under which they are incorporated. So these are registered companies. So the rights of companies, the liabilities of the members, anything, all are governed, all act according to the provision of Companies Act only, okay. And these companies can be public limited company or private limited company, but finally they can be considered as registered company. Either they will be registered as public limited company or else private limited company, okay. And coming to this second aspect, types of companies means classification on the basis of liability, okay. So liability means the person is responsible, okay, obliged to company or to a member, okay. So how would be that responsibility, how would be that liability? Liability may be in the terms of monetary terms here in, okay, in the company. If we see related to company, liability will be related to monetary terms only. So therefore liability means here it can be of two types. One is limited liability and unlimited liability, okay. So limited liability by companies, okay, limited liability companies, unlimited liability companies. So limited liability companies are those companies, the liability of these companies is limited only, okay. It can be limited by the number and the value of shares or, okay, limited by guarantee. We can see this limited means limited may be of limited by guarantee or else limited by share capital, means limited to certain amount, okay. So for example, the liability of a shareholder is 10,000, he has to pay 10,000 amount to the company, he owes 10,000 amount to the company. So his liability is limited to 10,000 only. Beyond that 10,000, the shareholder will not pay to the company, even though the company asks him, okay, he is not liable to pay above 2,000 because he is unpaid to 10,000 worth only. Therefore the liability is limited, okay, to that is known as limited to share capital, okay. So if at all it is a guarantee means, okay. So if we see limited by guarantee, okay, which comes under section 2 subsection 21 of Companies Act, okay. Limited by guarantee means in this type of company, the liability of each member is limited to such amount as to the member may undertake to contribute in the event of its being wound up. When the company is going to winding up of company, at the time of winding up of the company, the shareholder or the member of that particular company, okay, he will guarantee some amount, okay, that he will pay some amount. It will not depend upon the share capital of that member, but it depends upon the member guaranteed amount only, okay, the amount which he have guaranteed to pay in case of companies winding up, okay. So that guaranteed amount only he has to pay. For example, if that shareholder, okay, he is an unpaid shareholder, okay, means if at all he is having 10,000 worth of shares, he paid 8,000 and 2,000 is unpaid, for example, okay. So now he has guaranteed some amount at the time of winding up of company. He guaranteed that he will give 5,000 amount, okay, okay. And at the same time he is now unpaid 2,000 worth of shares, so 5,000 plus 2,000 becomes 7,000. So at the winding up of company he should pay 7,000 to the company. Or else if the shareholder has paid fully, okay, he has 10,000 worth of shares, he paid full amount 10,000, okay, he is not liable to the company, but he had guaranteed the company at the time of winding up of the company, I will pay 5,000, okay. So at the time of winding up of company, as he guaranteed 5,000 of amount, he should pay at that time 5,000, even though he is not liable to pay towards the share capital, because he paid full 10,000 shares amount, but he is guaranteed that at the time of winding up of company I will pay 5,000. So therefore he has to pay that 5,000 amount guaranteed by that particular member, okay. So this is about limited by guarantee. If we see limited by share capital means, this is according to section 2 subsection 22, the liability of members of such a company is limited by the face value of shares held by them, the real value of the shares held by them, okay. So if a member has paid the total value of shares held by him, he cannot be asked to pay any more amount in case the company suffers a loss, okay. So limited by share capital means, so the person is responsible to the unpaid amount only. For example, the same example if we take here means, the shareholder has 10,000 worth of shares, he paid 8,000 to the company, now his unpaid amount is 2,000, so he is liable to that 2,000 amount only, limited by share capital, okay. When the company is in loss, okay, he has to pay that 2,000, okay. Or else if he is fully paid, 10,000 amount is paid by him, okay. At the winding up of company, the company cannot ask that shareholder to pay the amount. Why? Because for 10,000 shares he had paid 10,000 amount, so he is unpaid, his unpaid amount is not there, he has fully paid the share capital, therefore company has no right to ask that particular member to pay the amount, okay. So therefore limited by guarantee means, at the time of winding up of company, the person who guaranteed should pay the amount irrespective of its unpaid shares or else paid up shares. But here coming to limited by share capital, if the person has fully paid the share capital and he is not owing any money to the company means, okay, there is no outstanding money to be paid by that particular member towards company means, the company has no right to ask that particular person. If at all he is unpaid to certain amount, for example 2,000 he has to pay to the company means, definitely the company could ask about 2,000 only, but not beyond that 2,000, right. This is about limited by guarantee, limited by share capital. Now coming to unlimited. So unlimited means, according to section 2 subsection 92, okay, a company with unlimited liability is one wherein the liability of member is not limited. Unlimited means there is no limited, okay. So unlimited, the members of such a company are personally liable for the debts of company, unlimited liability. companies are also not very popular here. Okay, so here members of such a company are personally liable for debts of company. So unlimited itself, we will say, we cannot say particular specific amount. Okay, so it depends upon the company laws, but persons will be personally liable to pay those debts. Okay, now coming to classification on the basis of control. Okay, so under control we will study about government company, holding company, subsidiary company, associate company. Okay, so what does government company means? Okay, see, government companies are those companies according to section 2 subsection 45 of Companies Act 2013. Any company in which is not less than 51% of shares, paid up share capital, is held by the central government or else the state government. Okay, or partially by central government, partially by one or more state governments, and also includes a company which is a subsidiary of government company. Okay, so government company means the company where central government or state government holds 51% of shares, means 51% of shares are owned by the government and 49% can be sold to the public. So such type of companies are treated as government companies, and here all subsidiary companies of the government company are deemed to be the government company only. Okay, for example, government companies in India are Hindustan Machine Tools. Okay, so finally we can say that government company means companies of 51% of shares are held by both central and state governments, or partially by central, partially by state and other governments. Okay, and now coming to holding companies. What does holding companies means? So according to section 2 subsection 46 of the Companies Act 2013, a company shall be deemed to be the holding company of another. Okay, if other company is its subsidiary, it means the company which controls another company is known as holding company. Okay, it means that holding company controls subsidiary companies. It means that more than half of the share capital will be with holding company only. Okay, and board of directors also composition control will be with holding companies only. Okay, so majority of directors also will be appointed by the holding company only. Okay, so holding company means basically we can say that the company which is having majority shares over other company. So if at all the company, for example, if the company is having 70% of holding shares on company B, okay, company is having majority shares of company B, then definitely company A will be treated as holding company. Okay, and the whole rights regarding the board of directors or else appointment of the directors. Okay, or else the control, all will be with the holding company only. Okay, so next one is subsidiary company. Afterwards, subsidiary company. According to section 2 subsection 87, what does subsidiary company means? A company shall be deemed to be a subsidiary of another. Okay, we can treat only subsidiary company when means, okay, if at all the other company controls the composition of its board of directors, like I said before in holding company. Okay, so majority of shares, if at all a company is having majority shares over subsidiary company, so definitely this subsidiary company is treated as subsidiary for another company. Okay, so where, for example, if we see holding company and subsidiary company. Okay, here holding company and subsidiary company. Okay, so this company can be treated as this company, holding company may be A company. Okay, so subsidiary is B company. So whenever this company is having more majority shares over B company, so this company is treated as holding company, this company is treated as subsidiary company. So then this company will have, if at all this company is having control over what to say, board of directors of the company. Okay, it can elect board of directors of the company. Okay, or else majority of directors are appointed by the company A, means it says that B is subsidiary to A company. Okay, then only we can say that company B is deemed to be subsidiary for A company. Or else that other holds more than 50% of normal value of its equity share capital, or more 50% of total voting power of company, then B company can be treated as subsidiary for A company. Okay, what is that? 50% of equity share capital is having more by company A. In such case, B is treated as subsidiary for A. Okay, or else if at all the A company is having 50% of voting share on B company, then also B is treated as subsidiary for A company. Means we can say that in electing board of directors, okay, in controlling board of directors, or else 50% of equity share capital, okay, more than 50% of share capital is having A company, means B is deemed to be subsidiary for A. Or else voting power, if at all the A company is having voting power, means definitely B is subsidiary for A. So in all that cases, subsidiary means B company will be subsidiary for A company. Okay, and the company is subsidiary of another company which is itself a subsidiary of some other company. It means that if company B is subsidiary of company A, okay, and company C is also there, for example C company is also there, B is subsidiary for A, okay, C is subsidiary for B. Whenever B is subsidiary for A, automatically C also will be subsidiary for A. It is deemed to be subsidiary for A. Okay, so the relationship of holding company and subsidiary company may also exist where there is no share capital. Okay, so even though share capital is also not there but voting power is there, means definitely it is considered as subsidiary for the holding company. Okay, and now coming to associate company. What does associate company means? Means associate company means, for example, X company, we are having company X, okay, and company Y. Okay, so X company is having significant influence on company Y. Significant influence on company Y. Then Y company is associate company of X. Okay, means X company 20% of shares. Okay, means between X company is having between 20% of shares, 20 to 50% of shares, not more than 50%, but between 20 to 50% of shares if X company is having on Y, means so this is considered as Y company is associate, okay, to X company. Okay, whenever X company is having significant influence, which is nothing but having holding 20 to 50% of shares in Y company, okay, then we can say that it as associate company. Okay, if at all if at all it exceeds 50%, means okay, it means it is having 51%, likewise, means then it will comes under the government company, or else this limited companies. Okay, so between 20 to 50% means it will be considered as associate company. Okay, so here under if we see under limited by share capital, I missed this concept. Okay, under limited by share capital, again we will study this into two aspects. Okay, one is private company. Okay, one is private limited company, other one is public limited company. Okay, okay, private limited company, public limited company under this limited by share capital. Okay, so what is private company and what is public limited company? Okay, so private companies can be studied under the head of section 2 subsection 68 of Companies Act. Okay, and this is studied, public company is studied under section 2 subsection 71 of the Companies Amendment Act 2015. So what does private limited company means? It defines private company as a company which has a minimum paid up capital as may be prescribed and by its articles according to section 2 subsection 8. Okay, minimum paid up capital, for example, before 2015 Act, okay, private limited company should have a paid up share capital of 1 lakh rupees. Okay, for public limited it should have 5 lakh rupees paid up share capital. Then it will be considered as public limited company, and it should have 1 lakh paid up capital share capital. Then it is treated as private limited company before 2015 Act. After this Act has came, after 2015 Act, this restriction has been taken off. Now there is no provision regarding this amount like 1 lakh and 5 lakhs. Okay, but there are what does this private limited company and public limited company means? Under private limited company, it restricts the rights of its members to transfer shares. Okay, under private limited company, transferability of shares is not easy. Okay, but in public limited company, transferability of shares is easily done. Okay, here it prohibits any invitation to the public to subscribe for any securities of the company in private limited company. Okay, it cannot go for invitation to public to subscribe for any securities. Okay, but here if we see in this case, it can go for public subscription in public limited company, but it is not that in private limited company. Okay, and here where two or more persons hold one or more shares in company jointly, they shall for the purpose of this clause be treated as single member in private limited company. It means that if at all two or more persons holds shares in a company, okay, so even though there exist two members or more than two members, all can be treated as one member only. Okay, so that is related to this private limited company. They are treated as a single member only. Okay, and the minimum number of members in a private company is 2. Here minimum is minimum number for private limited company directors should be 2. Okay, and coming to maximum number means maximum number for private limited company means 200. Okay, minimum is 2, maximum number members should be 200 for private limited company. if we see for this public limited company means, okay, minimum number will be 7 here, okay, minimum will be 7 and maximum will be infinity, okay, infinity means no limit, okay. So this is about public limited company and private limited company, okay. And another thing is that at the last name of a company, it should add private limited company. For example, Northern North company is there, so at the last name should be Northern North private limited company. Likewise here also, public limited company, X limited, X public limited company. Likewise, the suffix should be added with private limited or else public limited company, okay. So this is the classification under limited by share capital, means we can say in one word, transferability of shares. Under private limited company we cannot transfer the shares, but here under public limited company we can transfer the shares and we can go for public subscription also. But here we cannot go for subscription, public subscription. At the same time we cannot have transferability of shares, right to transfer the shares, okay. So this is about limited by share capital. Under limited by share capital we will study about private limited company and private public limited company, okay. So this is about the differences, types of companies. And one more thing, not only regarding incorporation, liability and control, there are certain other companies, other type of companies are also there, okay, which are going to study ahead. Now what are those other companies means? Types of companies, okay, other type of companies. One is one person company, small company, foreign company, section 8 company and producer company, okay. So if we see these companies, okay, so first one is one person company. Here one person company means according to section 2, okay, according to section 2 subsection 62, one person company means a company which has only one person as a member, okay, only one person will be the company member. So such type of companies are considered as one person company, okay. So these companies enjoy certain privileges and also certain exemptions as compared to other companies like public limited company and private limited company. It do have some privileges and some exemptions also. So if we think, do we have companies like one person companies means, yes, we have one person companies. For example, Yuvendra Agro private limited company is there, okay, which is OPC, which is located in Kanpur, okay. So likewise certain companies are there like one person companies. So what are the rules and regulations regarding one person company means? So if at all a person want to keep one person company means, he should be Indian citizen, okay, he should be Indian citizen and Indian citizen plus resident of India also, okay, Indian citizen at the same time resident of India, okay, Indian citizen, resident of India, both should be there. So then it is considered as one person private limited company. And here we have some exceptions also under one person company limited, okay. So certain exemptions, like for example under members, how many members should have under one person company means, minimum number is 1, maximum number is also 1, okay. Minimum number and maximum number for one person company is only 1. If at all there is in case of death, okay, in case of death of a one person company means, then who will become means, another member will be the nominee. Nominee becomes again OPC of that particular company, okay. And for that particular nominee, he should be Indian, okay. And also that person the person should be reside in India not less than 182 days in preceding calendar year. Okay, that means he should stay in India before previously 182 days, not less than 182 days in that calendar year. Okay, and so at that time, in that situation, okay, in case of death, such persons can be taken as a nominee for that particular company. And here under one person company OPC, for year 2 board meetings should be conducted in a calendar year. Okay, and for this we have minimum 1 director and maximum 15 directors we can have. Okay, even though we said that it is a one person company maintained by only one person, but maximum number can be, okay, 15 directors, but minimum is 1 director. Okay, so this is about the OPC one person company. Now coming to small company, what does small company means according to section 2 subsection 85? Okay, what small company means, it defines that other than a public company it can be called as a small company. Okay, other than a public company means so a small company have paid up share capital and turnover. If we see paid up share capital, okay, paid up share capital should be 50 lakhs. Okay, 50 lakhs to 50 lakhs, 50 lakhs to 500 crores. Sorry, 50 lakhs to 5 crores means it should not exceed 5 crores in a small company. Okay, so paid up share capital for a small company, so the company which is having 50 lakh of share capital, paid up share capital, and it should not exceed 5 crores. So what does paid up share capital means? Paid up share capital is nothing but we are going for the public subscription, means public will invest in our company, so investment will be taken, amount will be collected from the public. Okay, and for exchange of shares we will sell shares to them and we will receive the amount, so that is known as paid up share capital. So this paid up share capital should be 50 lakhs and it should not exceed 5 crores. Okay, so that such type of companies are considered as a small company. And in the same way, the turnover, okay, if we see turnover of a company, okay, turnover of a company. So the turnover of a company should be 2 crores. Turnover is nothing but the sales of a company. Okay, so it should not exceed 2 crores. Sorry, 20 crores. Okay, 2 crores should be minimum 2 crores. Turnover should be 2 crores and it should not exceed. Okay, it should not exceed 20 crores. 20 crores, it should not exceed 20 crores. Okay, turnover should be 2 crores and at the same time it should not exceed 20 crores. So small company, if we want to define a small company, means paid up share capital should be 50 lakhs and it should not exceed 5 crores, and at the same time the turnover of the company should be 2 crores and it should not exceed 20 crores. So the such type of companies are treated as a small company. Okay, and at the same time it should not be holding company or subsidiary company. So this is very important. Small company means it should, we studied previously like holding company and subsidiary company. Okay, so what are holding companies and what are subsidiary companies we have studied. So such type of companies are not considered as small companies. Okay. Now coming to foreign companies. So what does foreign company means? According to section 240, subsection 42, the company which is incorporated outside India, which is registered outside India. So those companies are known as foreign companies. Okay. So here we can say that which is incorporated outside India plus working in India electronically or physically. Okay. So such companies are treated as foreign companies. And for example, a company is incorporated outside India and carries on business in India while all its members are citizens of India is a foreign company, because both the elements, company being incorporated outside India and company carrying on its business in India, are present in this case. That is why it is treated as a foreign company. Okay. So if at all the company paid up share capital is not less than 50% of equity and preferential shareholders, and also it is having Indian citizen as the owner of the company. Okay. Or else the Indian citizen having both equity and preferential shares, then this foreign company will become as Indian company according to section 9 of the Companies Act. Okay. So actually foreign company means which is incorporated outside India and at the same time which has a place of business in India, whether by itself or through an agent physically or through electronic mode, and conducts any business activity in India in any other manner. Okay. At the same time, if at all any Indian citizen is there who is holding 50% of paid up share capital or equity share capital or preferential both, having an being an Indian citizen, okay, then this foreign company will become as Indian company also according to section 9 of Companies Act. Okay. Now coming to section 8 of Companies Act. So under section 8 of company, which companies are treated as section 8 companies? Okay. So section 8 companies are those companies which are in association, not in association with profit. Means those companies aim is not for profit. Okay. So such type of companies which promotes culture, art, education, research, sports. Okay. So such type of associations or else companies can be named as section 8 companies. Means purely the profit also they will spend that profit of an company also for the welfare of the nation or else welfare of the public. So such type of companies are treated as section 8 companies. Okay. And such type of companies need not be a separate firm or else which is a partnership firm also. Okay. And here this type of companies, actually company means at the suffix of the company name it should use the company limited or else private limited. Both public limited or private limited, a suffix should be added at the last of the company's name. But in section 8 companies, okay, these type of companies need not to use either public limited company or private limited company. Why? Because basically these type of companies are treated as associations which are not meant for profit. Okay. They aim for the promotion of culture, promotion of art, religion, education, research, sports, etc. Okay. And even though if at all they gain profits, means they will again spend that profit in the welfare of the public only. Okay. So that is why these companies are treated as section 8 companies, and those are treated as companies only. Okay. Even though at the suffix of the company name there is no public limited or private limited, it is treated as a company. Okay, and finally, producer company. So what does producer company according to section 581 1956 Companies Act, okay, related to agriculture based products. Okay, so companies which produce agriculture based products, such type of companies are known as producer companies. Okay, so these are the types of companies which are there in the Companies Law Act.